Will the women prevail in their lawsuit? State A requires all state park rangers to pass a fitness test in order to be hired for a job as a state park ranger. The justification is that the job requires intense physical activity. Primarily men apply for the job. Last year, 50 men applied for the job as a state park ranger and 10 women applied. 30 people passed the physical fitness test. All were men. The women brought a lawsuit claiming that the physical fitness test violated the Equal Protection Clause of the Constitution of the United States. Will the women prevail in their lawsuit? A says no, because the state can show that the fitness test is substantially related to an important governmental interest. This lawsuit is based on equal protection, so I'm automatically thinking about those levels of scrutiny. Strict scrutiny, intermediate scrutiny, and rational basis. Strict scrutiny will apply to things like race, alienage, national origin, and the fundamental rights. Those fundamental rights are the right to vote, free speech, interstate travel, and the right to privacy. There's a bunch of others under the right to privacy, but that's not what we're seeing here, so it's not strict scrutiny. Now, intermediate scrutiny will apply to things like gender and illegitimacy. When looking at these facts, I initially was thinking, okay, intermediate scrutiny because this is a law that discriminates against women. But then I thought about if the impact of the law has a discriminatory impact, but that's not why the law was enacted, then you don't use intermediate scrutiny. That would actually be rational basis. So rational basis would apply to everything else that's not strict scrutiny or intermediate scrutiny. With rational basis, we know that the plaintiff has the burden to show that the law is rationally related to a legitimate interest. Substantially related to an important governmental interest is intermediate scrutiny, but this won't receive that heightened level of scrutiny because the law was not created to purposefully discriminate. B says no, because there is a rational basis for the physical fitness test. That's looking good because it uses the words rational basis, and we know that this is going to use the rational basis test. C says yes, because the state cannot show that the fitness test is substantially related to an important governmental interest. That's just like A, but flipped, and again, it's still using that intermediate scrutiny standard, so it's not going to be C. D says yes, because the women can demonstrate a discriminatory impact. And although that might be true, that's just not the standard. So I'm going to say it's B. The answer is B, and that's because this law doesn't specifically make a gender classification. That one can be tricky because I see gender in these facts and I immediately want to think intermediate scrutiny. You have to distinguish between discriminatory impact of the law.